Thank you very much. Bismillahirrahmanirrahim. In the name of God, the Beneficent and Merciful. Assalamualaikum warahmatullahi wabarakatuh. Magandang umaga sa inyong lahat. Honorable Angelo Jimenez, President of the University of the Philippines, Honorable Carlo Fistan, Chancellor, University of the Philippine College of Law, Honorable Parolian Paidi Aritonang, the Dean of Faculty of Law, University of Indonesia, His Excellency Lieutenant General Retired Agus Sujoyo, Ambassador of the Republic of Indonesia to the Republic of the Philippines, who are represented by political attaché of the embassy, esteemed professors and lecturers of the College of Law, University of the Philippines, distinguished participants, ladies and gentlemen. First of all, allow me to express my sincere thanks and highest appreciation to the chairperson of the Legal Forum and the Dean of College of Law, University of the Philippines, who giving me the opportunity to stand here before the legal academics and University of the Philippines to deliver an academic address entitled Bridging Legal Cooperation between two countries in providing direction for resolving legal issues between both governments. My title assigns to me is indeed very interesting, not only as it is academic significant for the legal studies at the university, but it's also expected to offer practical solutions to issues that may arise when legal cooperation between the Philippines and Indonesia encounters obstacles. Such situations are understandable due to many factors. Also, Indonesia and the Philippines are neighboring countries. Through their histories, both nations have developed their own legal systems. While they share certain similarities, they also naturally possess differences. As an academician, I am particularly interested in examining these matters from the perspective of comparative law. These perspectives not only help in identifying commonalities and differences, but also plays an important role in building bridge to find solutions to the shared challenges we face. Indonesia and the Philippines are two nations of the same stock, rooted in the Austronesians, Malay-Melanesians cultural heritage. Individuals and communities from both countries have been constructed long before the modern state of the Republic of Indonesia and the Republic of the Philippines came into being. Linguistically, there are fundamental similarities between ethnic languages across the Nusantara archipelago and ethnic languages in the Philippines. Even when local languages were elevated to national status, the modern Malay as Bahasa Indonesia and Tagalog as the Filipino, we can many similarities, vocabularies indicating that these two nations are indeed of the same linguistic and cultural lineage. Colonialism later separated these kindred nations, erasing long-established people-to-people and community ties, as well as political relationships, as it is followed by history. There are close familial ties between the royal families of the sultanates of Mindanao and Sulu and those who held Mahendra in the North Maluku Islands. In fact, some historical accounts indicate that Raja Sulaiman, the king of Manila, who founded the kingdom along the Pasig River, was believed to be a nobleman from Minangkabau, West Sumatra. Many Indonesians believe that the name of Manila, used by Raja Sulaiman, derived from the Arabic phrase, fi amanillah, that means a peaceful land under the protection of Allah, or protection of God. Whether it is not, this claim is true, we leave it to the competent historian to study about it. Another fact that illustrates the close relationships between our kindred nation is seen during Indonesia's struggle for the independence. Between 1945 to 1949, as Indonesians fought against Dutch colonialism, they received assistance from Filipino political figures and community leaders. We will always remember the contribution of General Datuk Salipada Khalid Pendatun, who later became the Philippine senator. He secretly smuggled weapons from South Philippines into Indonesian territory of Sulawesi Island to assist our freedom fighters. We also cannot forget the support from the Philippine government, which in 1947 invited the Indonesian government to attend the Economic Commission for Asia and the Far East, ECAFE, conference in Manila, now known as CAPE, and based in Bangkok, Thailand. That invitation indirectly amounted to the Philippines recognizing the Republic of Indonesia as an independent state in the Asia-Pacific region. Historical records show that the Republic of Indonesia was only formally recognized internationally on August 17, 1950, when it was admitted as the member of the United Nations. Distinguished guests, ladies and gentlemen, a brief look into the past, however, fleeting, is essential to strengthen the good relations between Indonesia and the Philippines that we have long built. The deepened the cooperation between the two countries were both nature goodwill, mutual trust, and a spirit of brotherhood, as well as uphold humanitarian values. The principles I just mentioned are enshrined in the fourth paragraph of the preamble of the 1945 Constitution of the Republic of Indonesia, which states, "Then the form of Indonesian government that shall protect all the people of Indonesia and the entire homeland of Indonesia and to advance public welfare, educate the nation, and participate in the establishment of the world order based on the freedom, lasting peace, and social justice. The independence of the Indonesian nation is hereby promulgated in the Constitution of the State of the Republic of Indonesia, which is established as a unitary state and form a republic sovereign by the people, founded upon belief in the one and only God, just and civilized humanity, the unity of Indonesia, democracy guided by the inner wisdom of deliberations among representatives, and the realization of social justice for all the people of Indonesia." In the context of international relations, the preamble of the 1945 Constitution clearly states that one of the goals of the establishing of the Republic of Indonesia is to participate in the establishment of a world order based on the freedom, lasting peace, and social justice. After stating in opening slide that independence is the right of all nations, therefore colonialism must be abolished in the world because it is not in conformity with humanity and justice. This is why, after standing firm as an independent nation, Indonesia began supporting the independence of ASEAN and African nations, giving rise to the spirit of Bandung during 1955 ASEAN-African Conference. The collective spirit promoted by the conference participants later became the foundation for the establishment of non-aligned movement, which remain active until today. Principles of fostering good relations and promoting global peace can also be found in the preamble of 1987 Constitution of the Republic of the Philippines, which reads, "We, the sovereign Filipino people, imploring the aid of the Almighty God in order to build a just and human society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessing of independence and democracy under the rule of law and a regime of truth, justice, freedom, love, equality, and peace to ordain and promulgate the constitutions." Furthermore, Section 2 of the Declaration of the Principles and State Policies affirm the Philippines renounce war as an instrument of national policy, adopt the generally accepted principles of the international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. This extract clearly shows that the Philippines and Indonesia share nearly identical foundation principles in establishing international cooperation based on lasting peace, equality, justice, freedom, cooperation, and friendship with all nations in the world. In Indonesian constitution, cooperation with other countries, particularly in the form of treaties, is governed by the Article 11 of the 1940 Constitution, which stipulates the President, with the approval of the House of Representatives, DPR, or Dewan Perwakilan Rakyat, may declare war, make peace, and enter into treaties with other countries. However, for other international treaties that have brought in fundamental impact of the life of the people, related to financial burdens of the state, and or require amendment of the creation of the laws, approval from DPR is mandatory. Ladies and gentlemen, the provision of Article 11 of 1945 Constitution are further elaborated in the law number 24 of 2000 on international treaties. Bilateral treaties with significant implications must be ratified by the House of the Representatives through legislations. Article 10 of this law also specifies that international treaties requiring ratification by law are those relating to political matters, peace, national defense and security, state sovereignty or sovereign rights, human rights and the environment, the creation of new legal norms, and foreign loans or grants. Other treaties do not require legislative ratification but might be ratified by presidential regulation. In 2000, the United Nations adopted the UN Convention on Transnational Organized Crime, UNTOC, also known as the Palermo Convention, which allows states parties to engage the legal cooperation bilaterally or multilaterally, including extradition treaties, mutual legal assistance in criminal matters, and transfers of sentenced persons. The United Nations also issued the Model Treaty of Extradition through General Assembly Resolutions number 45-117 on December 14, 1990 as a reference to drafting extradition agreements. Further international cooperation in criminal matters is also regulated by United Nations Conventions Against Corruption, UNTAC, adopted in 2003, that I myself involved to draft these two conventions, Palermo Convention and UN Convention Against Corruption, and I, on behalf of the government of Indonesia, signed that convention to announce that Indonesia become a part of the convention. And a few years after that, we ratified and become part of the international national law. Consistent with the above framework for the international cooperation and treaties, the Republic of Indonesia has signed a number of bilateral treaties, starting with the extradition treaty with the government of the Philippines, signed in Jakarta on February 10, 1976. This treaty was concluded before the adoption of the UN Convention of Transnational Organized Crime, the UNCAC, and the UN Model Treaty of Extradition. It was second extradition treaty entered by Indonesia following the earlier treaty with Malaysia. This extradition treaty also became the first bilateral treaty between Indonesia and the Philippines to be ratified by Indonesia's House of Representatives through Law number 10 of 1976, enacted on July 26, 1976. Meanwhile, the House of the Representatives of the Republic of the Philippines ratified the treaty on October 25, 1976. The treaty is recorded in the Philippine Treaty Series number 667 and registered under UN Treaty Registration number 15177. The extradition treaty between Indonesia and the Philippines adopts general principles of extradition as recognized in international law, including the type of crime committed by the subject requested for extraditions must also be recognized as a crime under the national criminal laws of the both parties. A subject involved in political crimes who has fled to the territory of the other party cannot be extradited. And the third, each party reserves the right not to extradite. It is our nationals upon request from to other parties. In addition to adopting general principles of international law, the extradition treaty is also based on mutual recognition of the legal sovereignty of both parties. What is categorized as a crime by one party must also be regarded as a crime by another. Furthermore, the treaty affirms that the procedures for arrest and surrender are subjected to the criminal procedural laws and protocol of each respective country. This indicates mutual recognition of national legal systems, both parties acknowledge and respect the arrest of the surrender procedures in accordance with their own domestic law. Because of Indonesia and the Philippine extradition treaty governs protocol concerning the territorial sovereignty of each country, especially when a criminal flees to another country, the two nations also discuss the ownership status of Miangas Islands, known in the Philippines as the Las Palmas Island in the South Mindanao Islands. Both parties deems it is necessary to clarify the ownership status of the islands group to avoid future uncertainty, particularly if an individual requested for extradition will hide in the islands located south of Mindanao and north of Celebes Island in Indonesia. Historically, these islands were disputed between the Dutch East Indies government and the Spanish government, a dispute that continued with the United States after Spain left the Philippines. In negotiations held in Jakarta, both sides finally agreed that Indonesia is the sole sovereign owner of the islands. This agreement was based on the Washington Arbitration Award, dated April 4, 1928, which ruled that the lawful owner of the islands was the Dutch East Indies, not the United States. Since Indonesia inherited the territory of the Dutch East Indies, the Miangas or the Las Palmas Islands are true as this part of the sovereign territory of Indonesia. With this agreement, Indonesia and the Philippines no longer have any land or maritime territorial dispute. Also, the delimitation of maritime boundaries between Mindanao and East Kalimantan and North Sulawesi remain to be finalized. Distinguished guests, ladies and gentlemen, in addition to extraditions, another breach of legal cooperation that Indonesia and the Philippines could establish is mutual legal assistance, MLA treaty in criminal matters, referring to the UN Convention on Transnational Organized Crime and UN Convention Against Corruption. Both Indonesia and the Philippines have ratified these conventions, which emphasize international cooperation in combating transnational organized crime and the recovery of assets obtained through corruption and stored in foreign jurisdictions. To implement the Transnational Organized Crime Convention, Indonesia enacted Law No. 1 of 2006 on mutual legal assistance in criminal matters. This law provides the legal foundation for the Indonesian government to request of mutual legal assistance and offers a framework for concluding agreements with other countries for its implementation. MLA includes assistance requests related to investigation, prosecution, and judicial proceeding in accordance with the laws of requested country. However, the implementation of MLA requires bilateral treaties, which must be ratified by Indonesian House of Representatives in order to be legally effective. MLA is also limited in scope, as the law explicitly states that it doesn't authorize the following matters. Extradition is not surrender of individual. Arrested of detention for the purpose of extradition is of surrender or surrender. Transfer of sentenced person or transfer of criminal proceedings. Also, MLA provides a significant framework for the legal cooperation between Indonesia and the Philippines. The two countries have yet to conclude a bilateral agreement to implement it. Additionally, Indonesia not yet made substantial amendment to the law of number 31 of 1999 as amended by law number 20 of 2001 on the eradication of the corruption in order to fully implement the UN Convention Against Corruption. As a result, international agreements with other countries concerning the handling of the corruption cases are still limited to the application of MLA and cannot yet be fully based on the UN Convention Against Corruption. Yet corruption remains one of the most serious issues faced by both the government of Indonesia and the Philippines. Therefore, I believe that cooperation between the two countries at tackling corruption, grounded in the UN Convention Against Corruption, is an important area that must be jointly pursued. Effort to overcome the legal gaps related to the treaties between Indonesia and the Philippines. The legal cooperation describes, based on the extradition treaties, MLA, or joint ratification of international conventions, is not always straightforward in practice. In extradition cases, the process of requesting the surrender of the criminal suspect who has fled or hiding in the territory of other party often involve long and complex diplomatic routes before the matter can be handled by the Department of Justice, involving both police and prosecutors. Even if requested state decide to grant the extradition request, the person's may file the legal objection in court and may appeal to the Supreme Court. This process can be time-consuming, especially when the subject possesses multiple passports or dual and multiple nationalities. International legal cooperation that is based on the treaty ratification by respective countries, also legally valid, still require the formulation and enactment of the corresponding domestic laws for implementations. Moreover, the realization of such cooperation often necessitates the establishment of additional unilateral or bilateral agreements with partner countries in order to operationalize the principle enshrined in the conventions. For example, mutual legal assistance in criminal matters and the transfer of sentenced persons, both of which are stipulated in the United Nations Convention Against Transnational Organized Crime, require the enactment of enabling legislation as well as the conclusions of implementation agreements with other state parties. As I previously noted, Indonesia enacted law on MLA in 2006. 2 years later, in 2008, Indonesia signed an MLA agreement with several countries, including Philippines, which was subsequently ratified through law number 15 of 2008. The core objective of this agreement is to promote reciprocal cooperation in the enforcement of criminal law, which include effort to locate individual documents and other forms of evidence, as well as the transfer of assets derived from the criminal activities, while the MLA agreement does not extend the surrenders of individuals, since such matters fall under the scope of extraditions. It nonetheless has opened the important avenues for the cooperation in combating criminal acts, particularly those categorized as transnational organized crime. With regard to the UNTOC, Indonesia has not, to this day, enacted legislation governing the transfer of sentenced persons. In 2016, the Indonesian government prepared 2 draft bills, one concerning the transfers of convicted inmates and another regarding the exchange of the prisoners. However, neither draft has been submitted to the House of Representatives, effectively resulting in a legal vacuum that precludes the implementation of the such transfers. Indonesia also did not inherit the colonial era laws from the Dutch East Indies administration that pertain to the transfer of sentenced person. The stance is contrast to the Philippines. While inherited Act number 1703 dated on August 31, 1907 from United States colonial authorities. As a result, following the ratification of the UNTOC, the Philippines was able to enter the bilateral agreements on the transfer of sentenced persons with several countries. This development was likely motivated by the large number of the Filipino diaspora and overseas Filipino workers living abroad, whose protection often requires government-to-government cooperations. Unfortunately, there are currently no bilateral agreement between the Philippines and Indonesia regarding the transfer of sentenced persons. As previously mentioned, this is primarily due to the absence of any Indonesian legislation governing transnational organized crime on the transfer of sentenced individuals. In instances where the legal cooperation between Indonesia and the Philippines is hindered by the absence of enabling statutory provisions, the countries must actively seek alternative legal pathway to overcome such limitations. Indonesia's legal system not only derives its fundamental framework from the continental European legal traditions, which place a strong emphasis on the principles of legality, means that no government action may be taken without express legal authorizations, but also incorporates elements of Islamic law and the legal tradition or customary law, or we say that adat law that follows by the common people in Indonesia. Islamic legal tradition emphasizes not only textual norms within the Sharia, but also permit interpretative reasoning or ijtihad that draws upon prevailing society's values. This approach allows for the derivation of the legal norms that are based on the public interest, or maslahah in Arabic, collective benefit, and humanitarian considerations. In Islamic jurisprudence, it is permissible to the government to adopt policies and measures even in the absence of the codified legal norm provided by the served common good. So, in the case of Mary Jane Veloso, the Philippine government's legal efforts, which involved engaging several professional Indonesian attorneys to seek clemency for Mary Jane Veloso, ultimately proved unsuccessful. The District Court, the Court of Appeals, and the Supreme Court of Indonesia all ruled that Mary Jane was lawfully and convincingly found guilty of smuggling 2.6 kilograms of heroin and sentenced her to death. Her petition to judicial review, which was supported by submission of various new pieces of evidence or novum, was rejected by the Supreme Court. The President of the Republic of Indonesia also denied her clemency request, thereby exhausting all available legal and extrajudicial remedies. Mary Jane came within moments of being executed with firing squad. However, her execution was postponed at the last minute when it was discovered that her case was connected to an ongoing criminal proceeding in the Philippines. Since that time, her execution has been suspended and she has remained in custody at the Wiragunan Correctional Facility in Yogyakarta of Central Java. At one point, the Philippine ambassador, Her Excellency Gina Jamoralin, personally met me and requested assistance in securing Mary Jane's release through any means that might be legally or diplomatically possible. A similar request was reiterated by His Excellency Ferdinand Marcos Jr. during his visit to Jakarta to attend the inauguration of the President Prabowo Subianto on October 24, 2024, A few days after my appointment, President Prabowo instructed me to explore avenues to resolve the matter of Mary Jane's detentions, taking into account humanitarian concern and the strong diplomatic relation between Indonesia and the Philippines. In my personal view, the most appropriate response to the Philippine government's request was to repatriate Mary Jane to her home country. However, it was essential for the Philippines government to submit an official and formal request addresses to the government of Indonesia. The request was eventually made by Secretary of Justice Jesus Crispin Remunda on November 13, 2024, and addressed to me in my capacity as coordinating Minister for Law, Human Rights, Immigration and Corrections. We subsequently discussed the request with the Philippine Embassy in Jakarta, and in response, we prepared a draft agreement entitled Practical Arrangement for the Transfers of Mary Jane Veloso to the Philippines. The document outlined the technical and procedural arrangement for the repatriation of the inmates applicable specifically and solely to the case of Mary Jane, not for the others. In the proposed draft, the Philippine government agreed to several key principles, including a formal recognition of the judicial decision rendered by the Indonesian court in Mary Jane's case, and a commitment not to contest the contents of the ruling even though the Indonesian court has sentenced her to death and the Philippines was abolished the capital punishment several years earlier. Mary Jane was to be transferred to the Philippines with the status of the death row convict in accordance with the final and binding decision of the Indonesian judiciary. The draft also stipulated that following her transfer to the Philippines, all matters relating to the management and rehabilitation of the inmates would fall entirely under the jurisdiction of the Philippine government. Whether Mary Jane would subsequently be granted clemency or a reduction in the sentence be left entirely to the discretion of the Philippine authorities. The government of Indonesia expressed its full respect for whatever decision the Philippine government might take. The Indonesian embassy in Manila later reported to me that that the Philippine government has not made any formal decisions regarding Mary Jane's sentence, and she remains in custody in a women's correctional institution in Mandaluyong. The Indonesian government does not object to this status. Our only request that we be granted access to information regarding any development undertaken by the Philippine government following Mary Jane's repatriations. Meanwhile, in another case, the French government took swift action as soon as we transferred its citizen, Sergei Altoa, to his country in February 4, 2025. Altoa was sentenced by the Supreme Court of Indonesia for establishing an ecstasy factory in Tangerang City, the Banten province, in 2005. The French government requested a reduction in sentence to 30 years in prison to the French court. The requests were granted as the maximum sentence under French law for the crime Altoa committed. The French government finally granted him parole on July 16, a few days ago, 2025, by considering Altoa had been detained in Indonesia for 20 years. The resolution of Mary Jane case was not based on any law, not on any treaty requiring ratification, and not on any international convention ratified by either the government of Indonesia and the government of the Philippines. As a result, the policy decisions made by the Indonesian government received criticism and scrutiny from several parties within the country, including politicians, members of parliament, and international law experts. Most of them argued that repatriation of Mary Jane was a violation of the law. I responded to this criticism by explaining that to date there is no existing law regulating the transfers of prisoners. Since such law does not exist, no legal violation was committed. My response was based on the principles in the Islamic jurisprudence, which state that what is clearly permitted or halal and what is clearly prohibited or haram is regulated by specific norm. Between what is halal and haram, there are matters for which no ruling has been clearly established. In such cases, decision must be made by the considering whether the benefit outweighs the harms. In my opinion, the benefit of returning Mary Jane to the home country override any potential harm. I also explained to the academic circles that in the absence of the specific legal provision regulating the matter, the President has the authority to exercise discretion, provided it meets the criteria set out on the administrative law. The transfer from Mary Jane to the home country was not an intervention by the President in judicial affairs, since the Supreme Court had already issued a final ruling in Mary Jane's cases. The execution of the conflict is an executive authority and part of the President's powers as head of the state. In Indonesia administrative law, there is a recognized principles that a policy, known the legal term as the beleid in the Dutch language, made by the government is not subject to judicial review as long as it's made in accordance with the general principles of the good governance. My promise that Mary Jane would return to the Philippines before Christmas was finally fulfilled. She set foot in Manila on December 20, 2024, after 10 years of diplomatic effort to bring home has failed. Thanks to goodwill, strong bilateral relations, and humanitarian consideration under the administration of the President Prabowo Subianto, Mary Jane case was resolved in less than 2 months, comparing 10 years the effort by both countries, but no result at all. As the Indonesian proverb says, there is no thanks thread that cannot be revived, meaning no matter how complicated the problem might seem, it can be solved as long as there are goodwill. In Indonesian phrase, tidak ada benang kusut yang tidak dapat diurai. It means that there's no problem cannot be solved as far as we have a good intention to solve these problems. In addition to the Mary Jane case, the governments of Indonesia and the government and the Philippines have cooperated in handling various terrorism cases involving Indonesian nationals. On March 13, 2002, 3 Indonesian citizens, Agus Dwi Karna, Jamal Balfas, and Tamsil Lindrung, were arrested in Ninoy Aquino Airport on charge of terrorism. Agus Dwi Karna was known as a Southeast Asian Al-Qaeda operative and was involved in terrorist training activities in Celebes Islands. At that time, as Indonesian Minister of Justice, I communicate with my counterpart, the late Simeon Dato Manong, Secretary of Justice of the Philippines, and we provided the Philippine government with data and information on these 3 individuals. Tamsil was released due to the absence of evidence linking him to terrorist activity in Indonesia, while Agus Dwi Karna was handed over the Philippines government to be tried in Pasay Court, where he was sentenced to 12 years in prison. He was released in 2014 and deported back to Indonesia. The series of events demonstrate how good a relation between Indonesian and Philippine leaders can transcend political and bureaucratic barriers. Likewise, in the case of Alice Guo, the mayor of Banban, Tarlac province, who was suspected in the spy, online gambling crimes, and money laundering, and who had secretly entered Indonesia legally through its immigration system, be provided all information about her whereabouts as requested by the National Bureau of Investigation (NBI) of the Philippine National Police after she was successfully apprehended by Interpol Indonesia on September 3, 2024, based on red notice issued by the Philippine police. She was then detained in a holding facility. The process moved very quickly. Just 3 days later, on September 6, 2024, Alice Guo was flown back to Manila under escort by the NBI and the Philippine National Police. The arrest and the repatriation of Alice Guo was not based on the extradition treaty or MLA agreement, but rather than more the direct approach police-to-police cooperation via Interpol, following instruction from the Indonesian government for the police to assist the Philippines, then return Alice Guo to her country. The legal basis for the cooperation between the Indonesian National Police and the Philippine National Police in handling the case of Alice Guo case was the MOU on cooperation in preventing and combating transnational crime and capacity building, signed in December 2022. Similarly, in the area of counterterrorism, there is a MOU between the National Counterterrorism Agency of Indonesia and Anti-Terrorism Council of the Philippines on combating international terrorism, signed in Manila on May 23, 2014. In my opinion, both MOUs are highly practical and effective in bridging and guiding legal cooperation between the two countries, comparing use MLA and extradition treaty. Distinguished guests, ladies and gentlemen, as two kindred and neighboring nations, Indonesia and the Philippines must continue to nurture the strengthened good relations in the years to come. Cooperation must not be limited to legal matters alone, but should also extend to the economic, political, and socio-cultural field. Legal cooperation is sometimes hampered by the absence of applicable legal norms, the slow pace of legislative processes, and the requirement for bilateral treaties. The examples I have presented earlier should further motivate us to prioritize mutual interests based on the goodwill, close ties, and humanitarian principles which can be overcome formal legal barriers. While the work of drafting and enacting the necessary laws, we must maximize the use of the intergovernment MOUs between the two countries to resolve issues more swiftly and practically. Personal and cordial relations between national leaders can also be highly effective in addressing problems through informal channels. This concludes my remarks. I hope they prove useful in promoting constructive relations between Indonesia and the Philippines. And thank you for your patience in listening to this academic address. And I apologize for any shortcoming in delivery. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.